So the question was asked in regards to the courts, what is the role of the Solicitor General? And I think this is a really interesting question about a very little known government official that plays a crucial role when it comes to connecting typically the executive branch and the congressional legislative branch with the judicial branch or the judiciary. The role of the Solicitor General was created in 1870 by Congress to coordinate government litigation. And this is kind of the point person for when the government is involved in dealing with lawsuits and particularly appeals work for that coordination to be effectively done. Now, the Solicitor General is, like many other judicial officials and members of the executive branch, appointed by the President, is confirmed by the Senate, and specifically, this position, by law, or otherwise known as by statute, quote, must be learned in the law. And so typically what we mean by that is have the law degree, the Juris Doctorate, and be admitted to a bar of a state or of perhaps the Supreme Court or of D.C. This is one of very few positions that has to be, quote, learned in the law to be appointed to this particular position. Now, the Solicitor General basically has a dual role, and I'm going to talk a little bit about this dual role through this video presentation. But you can think of the two roles of the Solicitor General as first being the federal government's lawyer in the judiciary. Now, a lot of people would think that this position as being held, the federal government's lawyer for the judiciary, would be held by the Attorney General. The Attorney General is seen more as the chief law enforcement officer of the federal government in the executive branch. What this role takes on is the federal government's lawyer in the judiciary, in the judicial branch. But there's another aspect to this particular role of the Solicitor General, and that he or she is considered to be an officer of the Supreme Court of the United States, sometimes referred to as SCOTUS. And so what this dual role does is that it requires the Solicitor General to strike a very delicate balance in doing their day-to-day activities. First and foremost, they have to represent the legal interest of their superiors. And who are their superiors? The President and the Attorney General. But they also have to think about the long-term interest of the United States as opposed to the current administration. Think about how this particular issue within the judiciary, what the government's reflection, what the government's point about a particular case may be long-term as opposed to short-term. And then finally, they have a responsibility as a special officer of SCOTUS itself. And so kind of balancing all of these roles is what I want to kind of explore and consider in this particular approach. So first and foremost, the role of the Solicitor General as an executive branch officer. What the Solicitor General will do is decide when the federal government will appeal a case that it loses. And this can be done kind of at the two stages of our federal judiciary system. A previous video that I hope you've watched talked about the hierarchy of our judicial system. And when there's an appeal from a district court to the Court of Appeals, it's the role of the Solicitor General to make that decision. And if there's an appeal wanting to go from the Court of Appeals to the Supreme Court of the United States, that is also a decision made by the Solicitor General. The Solicitor General's role as an executive branch officer is to decide when to file an amicus brief in cases on appeal. And remember, an amicus brief, as talked about in the textbook and in previous videos, is basically a friend of the court. I'm an interested party as the federal government. I'm interested in this particular case. Here are my thoughts, my recommendations. That's what an amicus brief is basically about. And this could apply to either the courts of appeals or the U.S. Supreme Court, whichever the Solicitor General decides. Solicitor General also chooses among the competing views within the executive branch, particularly when it comes to the arguments about being made in a particular case. Different agencies within the federal government may look at the same law or the same case in very different approaches, and it's up to the Solicitor General to decide what is going to be the view of the executive branch when it comes to trying to resolve this particular case and make that advocacy to either the courts of appeal or to the Supreme Court. Finally, the Solicitor General, as an executive branch officer, gets to decide and determine when to defend laws passed by Congress. This oftentimes goes before the U.S. Supreme Court, and it is within the discretion of the Solicitor General to decide, you know what, maybe it's just not worth defending this particular law passed by Congress within the courts. That is a discretionary authority and power that the Solicitor General has. To move on to the other role of Solicitor General as an officer of the Supreme Court. And this is a very important role that the Supreme Court vests a lot of authority and recognition into, because what the Supreme Court wants is an honest assessment of when there is a question about federal law, or even when sometimes there may be issues about constitutional rights. The Supreme Court seeks of the Solicitor General their opinion about, does this particular case, the merits of this particular case, the facts, the issues, the questions, does this merit the Supreme Court's attention to deal with? And if the Solicitor General suggests to deny review, to deny the granting of certiorari, as discussed in a previous video, oftentimes the Supreme Court will rely heavily on this particular suggestion. Now, you may ask, why would the Supreme Court rely on an executive branch officer to give them a recommendation to either accept or deny certiorari for a particular case? Well, perhaps the Solicitor General looks at a case and decides, you know what, this isn't really sufficiently important. It doesn't have enough merit to really warrant the Supreme Court's time and effort on a particular question of federal law or on the question of federal constitutional rights. And it's something more than just saying, you know what, the federal government, the executive branch, is opposed to this particular view. It's not about that. It's not rather than simply contrary to the government's views. It's about the learned interpretation and application of the law by the Solicitor General for the entire federal judiciary and the executive branch. Now, if the Solicitor General suggests that SCOTUS take the case, that they grant cert and accept a review of the case, that means that that particular case is substantially important for the court to weigh in on and settle a particular dispute or issue. So when it comes to the role of the Solicitor General, what it has been described oftentimes is as a gatekeeper, or sometimes referred to as the 10th Justice of the Supreme Court, because they have such an influential role in setting the agenda, in sending cues and signals to the Supreme Court. Now, the Supreme Court may actually also ask the Solicitor General not just about should we review this particular case, but what does the Solicitor General think about an issue of federal law in which the government is not a party? And so they're seeking kind of outside counsel, outside perspective, and that's the role of the Solicitor General. Oftentimes you will hear it referred to as calling for the views of the Solicitor General. You oftentimes don't hear this in public parlance, but if you go into the legal community, this is a very powerful aspect to the Solicitor General's role. Now, oftentimes the Solicitor General is required in terms of preparing an amicus curiae or amicus brief. Again, that's friend of the court. The Supreme Court perhaps wants the government's view. In order to convey that view, the Solicitor General and his or her staff will prepare the amicus brief or the amicus curiae brief giving that governmental review. And oftentimes the Court General requests the Solicitor General's views more than 10 times a term. So they are an active part out of considering 70 to 75 to maybe 80 cases a year. At least 10 times a term, the Supreme Court will call on the views of the Solicitor General. Now, the power and the role of the Solicitor Generals has kind of been expressed here, that dual role, but it's also been a kind of stepping stone from this position, oftentimes to higher positions, most notably on the court itself. Considering that the current Chief Justice of the United States, John Roberts, he had previously served in the Solicitor General's office during Republican administrations. And in fact, one of the current Associate Justices, Associate Justice Elena Kagan, she actually served as the Solicitor General of the United States and is now on the Supreme Court of the United States. So when it comes to the role of the Solicitor General, it's a unique role within our government between the executive branch and the judicial branch. It's not really well known outside of the legal community, but it is a highly influential position within our government and can shape what the law is for the future of the country and for its citizens.